Assalamu alaikum and good evening. Welcome to Legal Ease, the show that converts legal jargon into legal ease. Thank you very much once again for joining us. And I know that it is a nice cold and rainy Thursday evening, but we hope to warm you up a little bit with some very important information and facts about this maze that we call the criminal law in South Africa. The show tonight is entitled, Yes, He Did It, but is that enough? The importance of forensic evidence in criminal trials. I know what you all might be thinking, who the he might be, but it's not specific to any specific case. It is in fact a general title for a general show, which we hope to cover a vast majority or a vast area, should I say, of the criminal law in South Africa, the criminal procedure in South Africa, the do's and don'ts of the state, the police, the prosecutors, the defense, and generally what happens in criminal matters from start to finish, including sentencing of an accused if in fact he is found guilty of an offense. We want to take this opportunity now to introduce the person that is going to be helping us through this maze. He's an advocate. His name is Deon Pool. He is a former magistrate of our district courts in South Africa. A lot of you at home might have appeared before him, so I hope you're not shuddering in your seats. And if you were an attorney appearing in front of him, I hope that you were successful. If not, then your clients are probably sitting in jail. If they aren't sitting in jail and they were guilty, well, then they should be sitting in jail. But on a more serious note, Advocate Pool was also a former prosecutor. And as he says, natural progression led him to the bar. He is an advocate of the South African courts. Without further ado, we'll introduce to you Advocate Deon Pool. Deon, thank you very much for joining us.
Thank you, Nadeem.
It's a privilege and an honor to have you on our show.
It's a pleasure.
Just generally speaking, if you can give me an introduction, where you started out, just a quick 2 minutes introduction on who you are, what you do on a daily basis today.
I started as a prosecutor, as you duly mentioned in your intro, and then in 1997 I was appointed to the district court bench as a magistrate. I performed my duties in Johannesburg and in surroundings. And last year in March I decided that it was time to move on, and I became a member first of the independent bar, and now I'm currently enrolled in the pupillage program in order to be considered to become a member of the Johannesburg bar.
Okay, so there's a difference. I mean, just very quickly, I don't want to necessarily stray on that, but there's a difference between the Independent Bar Association and obviously the either Joburg or Pretoria Bar or Cape Town, wherever you are. There is a difference. What is that difference?
Fundamentally, the difference is that the Johannesburg Bar is aligned to the Society of Advocates. It is a society that adheres to certain code of conduct, which is specifically applied to all its members. It's a cohesive and a distinguished environment in which you find a lot of most of the practicing advocates in South Africa. Mm-hmm. And it's important to have a collectiveness and a
support structure. Really.
A support structure.
Yeah.
And necessarily that's why I have gravitated towards that.
Okay. Now, Advocate, you have been on both sides of the fence. You started out prosecuting, and then obviously you presided over criminal matters, and now you're an advocate, and so you're defending these potential accused or potential criminals or whatever you want to call them. So there's a lot that we can discuss insofar as your experience goes. Just let us start with where you started, essentially being a prosecutor and then being a magistrate. Would you say that we have elevated in South Africa from a criminal perspective? And are we on a similar or same playing field as, say, the international criminal courts?
Nadeem, that's a very interesting question. I had a similar discussion with a colleague of mine the other day. I fundamentally believe that South African jurisprudence in general, and specifically our criminal courts, to a large extent functions a lot better than our counterparts in America, with due respect. Because I am of the opinion that the checks and balances that are in our justice system ensure that eventually justice is properly done. And by checks and balances I mean that yes, there is a presiding officer that is making a decision based on the facts before him or her, but those facts have to be decided upon as far as the evidence is concerned and the application of the law that relates to it. And if you look at our law, we've got a Roman Dutch heritage as far as our common law is concerned. We've taken, the English law has influenced to a large extent the way that we procedure our law, and our constitution is predicated to a large extent on the Canadian constitution. And I firmly believe that we have taken the best that there is in the world, and we have developed our legal system accordingly. And our legal system still grows, and it is still evolving, and it is still developing. We are a young democracy.
Correct, yes.
And as our communities start developing changes, we necessarily have to adapt the law, and that is happening on a daily basis. On a daily basis, our courts are deciding and creating new law, and in various instances are dictating to our legislative arm to make new laws in order for our inclusiveness in this country to be celebrated.
Now, it's interesting that we have someone who was a former presiding officer, a magistrate, because if we've ever tried to secure an interview with a magistrate or a judge, obviously, as you can very well imagine, they are controlled by very stringent laws and rules insofar as that is concerned, for obvious reasons. So too are prosecutors, might I mention. You have to really do quite a bit of motivation before you get them on the show. So it's interesting that you're here because as I mentioned to you, the show is interactive, so we take tweets throughout the show, but we also take phone calls. And the phone calls, just to inform our viewers, the phone calls will start in the second half of the show. We'll start the phone calls a little bit earlier tonight because I'm sure they have many burning questions. One of those questions, I'm pretty certain, are going to be, Advocate, as a magistrate or as a prosecutor, you say that we really do strive to get justice done. A lot of people will sit at home thinking, but how come then a baby rapist or a criminal, a murderer or a general rapist, those types of guys are getting bail in amounts of between 2,000 and 5,000 rand, but then you've got a situation where a fraudster might be sitting in jail all the way up until such time as the trial. Now, I know already the answer that you're probably going to give, but for purposes of the viewers, what is the distinction that a magistrate or a bail magistrate makes in a situation like that? We know that bail is not punitive in nature.
Bail is not punitive in nature, and it's an ongoing debate. And necessarily, it's a debate that, to a large extent, is informed and predicated by the experience that the public and the general society have of the way that the criminal courts in South Africa function. Bail in general is governed by Section 60 of the Criminal Procedure Act, and as the Act describes, it's the procedure that is followed in all criminal matters from start to finish.
Correct.
So when an accused is arrested, he necessarily has to appear in front of a magistrate, and based on the schedule that the accused crime falls under, because the Criminal Procedure Act makes allowance for various schedules. Those schedules each contain different crimes, and based on the schedule, in that sense, the bail is necessarily attended to accordingly.
Okay.
Rape and fraud don't fall under the same schedule. Depending on the seriousness and the aggravation of the rape, it will either be Schedule 5 or Schedule 6. Whereas fraud, depending on the amount, would go under Schedule 1, and the onus of bail for a Schedule 1 offence is not as high as the onus for a Schedule 5 or a Schedule 6 offence, which shifts the onus, quite frankly, from the state to prove that bail should not be allowed, to an accused having to prove that exceptional circumstances exist in which he should be given bail.
Okay.
So the distinction is very important to understand, and from that point of view to then look and also have regard, yes, it might sound like an excuse, but to have regard for the challenges that our courts have to go through on a daily basis. It's extremely difficult in an environment where you don't necessarily have specific time to consider every single aspect. You're not running one case a day, you're running 10.
Yes.
As far as the lower courts are concerned. And sometimes the ball does get dropped, but that brings me back to my point of the checks and balances. Once again, anybody who is not satisfied, and necessarily in a criminal environment, the state represents the community. Anyone who is not satisfied with a decision that has been pronounced upon them or upon a matter in which they have an interest has the right to appeal. And our courts in general are very strict about appeals.
Correct.
And there are several hoops that anyone has to jump through, any interested party they can jump through, if I can put it plainly, in which satisfaction as far as the law is concerned can be achieved.
Okay. Well, that makes a lot of sense, and it helps us to understand that, yes, there is method to the madness, so to speak. 22 years on the bench. It's fair to say that you've dished out a fair amount of convictions in that time. Are you then happy with the state of where we are procedurally and substantially as a legal justice system, a criminal justice system? You happy with where we are, status, how it runs, how it operates, the procedures being complied with, etc.?
Nadeem, I think it's important that there is a distinction drawn between the law itself, the principles of law, and the practice of that law.
Okay.
And principles of law, as I indicated to you, I believe that our country has got one of the best legal systems in the world, our criminal as well as our civil law. It's a law that has been developed and is still developing as we are going along. But necessarily the practice of law in South Africa is a completely different kettle of fish. In some instances, it seems to be easy, it seems to be a commonsensical, if I can put it that way. It seems to make complete sense and be a matter of common sense. But unless you are in the environment, in the arena, so to speak, and being a party to those proceedings, it's very difficult to sit in an armchair perspective and to say, but that should have happened like that, and that should have happened like that. Yeah. I think that privilege is only afforded and should only be afforded to the people who are actually part of the process.
Absolutely.
And who are driving a matter in respect of each party that they represent.
I must say, Advocate, and I'm really glad that you made that comment, because every person sitting at home who has obtained an LLB by Twitter, to be quite honest, in my opinion, really cannot pass judgment on the process of certain matters that are either being televised or not being televised, or that they have an interest in. Yes, we understand as South Africans and as lay persons, we all have an interest in what happens in our criminal justice system. Doesn't matter to who it is, doesn't matter to who the accused or the victim may have been. The fact of the matter is, there is a course of law. We should have faith in that course of law, that the course of law will take, or the justice will take its course, and that justice will be meted out in the fairest and most equal manner possible. So I'm glad you made that comment. Now, we're going to take a short commercial break in a few seconds. When I come back, I want to talk to you about specifically procedure. The Criminal Procedure Act 55 of 1977. That is the act that governs any crime or any offense committed in South Africa. Is that correct?
Correct.
So we're going to look at when we come back, from the start of an offense to the sentencing, if guilty, of the accused, when we come back. Until then, Jazakallah for joining us. We'll see you very shortly on Legal Ease. Assalamu alaikum, welcome back to Legal Ease, the show that converts legal jargon into legal ease. And tonight, we are trying desperately to convert this legal jargon of the criminal justice system in South Africa today into an easily understandable and hopefully sensible understanding to our viewers. As mentioned before, we are with Advocate Deon Pool. Advocate Pool is essentially an advocate in the South African courts, the High Courts of South Africa, formerly, as we mentioned, a magistrate of the district courts. I'd like to remind you that this is an interactive show, and we'll be opening the phone lines now. The number to call is 011 086 7701 or 2 or 3. The number is obviously also appearing on your screen as usual. Please call in or tweet to @LegalEase. On Twitter. We wait for your calls, and while we do that, we'll be continuing our conversation with Advocate Pool. So, as I mentioned before the break, Advocate, Criminal Procedure Act, it is essentially the law that governs a crime in South Africa. Just explain to us, procedurally speaking, the do's and don'ts of a police person first arriving on the scene, actually of the accused person who may now become, or the person who may now become the accused person in a crime or in the committal of a crime, and then all the way up to the trial. What is the procedure involved in a nutshell? How does it start? What are the important elements of the procedure of that crime?
Necessarily depending also on the kind of crime that's committed. We can use the example of a theft at a house. You would phone the police, they would arrive at your house, either take a statement from you, or you would go to the police station and make a statement at the police station if need be. That would be compiled into a docket. The docket would be handed to an investigating officer who is not the same person as the person that might have taken your statement. The docket would go to a prosecutor. If a suspect was at that point in time already identified, the same suspect would then be arrested and brought into custody at the police. Under those circumstances, depending on the nature of the offence, the suspect would either be given bail at the police station and warned to be at court, or he would appear at court the next day or the following day within a 48-hour time frame and then be arraigned in the courts, where he would then be afforded an opportunity to get legal aid or legal representation.
Correct, yes.
As it is one of the fundamental conditions of our Constitution.
Okay. Let me stop you there for a second and ask this question. So already now the accused has been brought to court for bail, and then obviously afterwards to a trial court, perhaps potentially to either now plea or not plea. How important at this stage already are the forensics, forensic investigators and the forensic evidence of this alleged crime? So now you're looking at a situation of a housebreaking or a theft. Slightly different, may not be that much evidence to gather at the crime scene. And when we look at a case like we were talking about just now, a murder trial, for example, there's a lot more. But how important is forensics already at that point?
Forensic evidence is very important if it relates to the crime at hand. If you take a house robbery, for instance, where apart from the robbery per se, there has been serious injuries or even deaths from the people living in the house, the fact that forensic evidence at that point can be gathered is extremely important, for the simple fact that there are not necessarily eyewitnesses to the event. In that regard, forensic evidence would have to be gathered in order to have ballistic tests done, to take the bullets that are at the scene, to compare them to guns that might be found at a later point in time in the possession of somebody, in order to create a nexus between the person and the crime that has been committed.
Okay. So having said that then, and something that my criminal procedure or criminal law professor advised us at UJ when we were at RAW said, so forensics ultimately and the gathering of forensics and the proper gathering of forensics essentially creates the scene for those who weren't there.
Yes.
Okay.
It can recreate the scene for
those who were there. So it's of absolute vital importance.
Yes, it's very important.
How, and I want to say the word, how competent, should I say, is our forensics in South Africa from an SAPS point of view? How good are we in that regard? I remember already at when we were at university, our professor said to us quite simply that we have the best CSI lab potentially in the world. We just don't have the manpower to man that lab. Is that still the case today?
I would predicate that might still be the case today, but also cautioning that there are people in our forensic environment, not necessarily part of the police, but there are forensic experts in South Africa that are absolutely at the top of their field. And in the police as well, there are people that have got an enormous amount of experience concerning all fields of forensics, and in most instances, other countries come here to come and learn about forensics, because our forensics deals with a very specific environment of crime, which is not necessarily available in other countries. And in that respect, I wouldn't go so far as to make a comment to say that our forensic is not as good as any other country. I think that in some respects it's on par, and in others it's even better. And I am aware of the fact that there are instances where other countries in the world come to South Africa in order to learn from us, just as much as we go to other countries in the world to go and learn from them.
Well, that's very comforting to hear. So, is it safe to say then that if the forensics, the gathering of forensic evidence, or gathering of evidence, because that's what it is, in a criminal matter, is botched up, that could mean the guilty or the acquittal or the conviction of an accused? Is that how valuable we can say the forensics is?
Forensics in that respect is a very precarious piece of evidence to collect, and the test for forensic evidence necessarily is high because of the probative value, or the proof value rather, that it carries in criminal trials, especially in trials where in most instances the guilt or innocence of an accused depends solely on forensic evidence.
When would that happen? When would that be, where it depends solely on forensic evidence?
Well, necessarily where there's no
eyewitnesses.
Where there are no eyewitnesses to the event, where...
or conflicting statements.
Or where you have, like the farm murders, where you necessarily only come upon the scene the next morning, and the only thing that you have is necessarily that which you find at the scene, as in the deceased, as in the forensic evidence and that type of stuff.
Okay. Let me stop you there, Advocate. We have a call on the line that's going to be asking us a question in regards to this, so let's help him and we might be able to continue our conversation with him. Assalamu alaikum, good evening, caller. You can go ahead.
Hi, good day. My name is Peter.
Yes,
I'd like to know, regarding the Oscar Pistorius case, how is the defense going to explain the discrepancies between the bail affidavit and the evidence that's come out currently?
It's a very, very, very good question, Peter. Thank you very much for the question. Advocate?
Nadeem, and thank you for the caller as well. It's necessarily, as far as the Oscar Pistorius matter is concerned, I'm not going to comment specifically on the matter because I feel that it is imprudent to do so at this point in time. The Oscar Pistorius matter is very early days, and there is still a lot of evidence that needs to be laid, and how that evidence is going to be tendered, how it's going to be handled by both parties, Mr. Nell for the state, Mr. Roo for the defense, is going to depend on a large extent as to the evidence that is still to be laid. And then at the end of it all, we will be in a position to understand exactly how all that evidence fits into each other. As far as the specifics of your question is, that is a matter that will have to be dealt with during the defense case. And when we get to that point where the state has led its final witness and has closed its case, we will then be placed in a position to understand exactly how the defense is going to approach those discrepancies, if they feel necessarily that which we consider to be a discrepancy is of such vital importance that it needs to be addressed.
Okay, so having said that, and we're getting to the end of the trial when it does come eventually, and people have been chirping about this, and I say chirping because that's what I call it. Well, they do it on Twitter ad nauseum. People have been chirping about this ad nauseum, and what they've been saying is there's going to be a technicality. There's going to be a technicality. Everybody talks of technicalities. Now, when I say technicality, when I hear technicality, I think of some sort of a breach in procedure. How detrimental to either the defense or the state's case could a breach in procedure be? We've talked about the Criminal Procedure Act.
Breach in procedure in what respect?
So we've got a call online, so let me quickly ask this question. But
okay.
So breach of procedure, where the Criminal Procedure Act stipulates that this must happen in accordance with, in the following manner. A must precede B, B must precede C, and this is how the trial must go ahead. Then certain judgments may or may not come out, which might deter from the procedural elements. So, for example, witness testimony, where we had a very brief discussion. So, witness testimony, for example, we had a brief discussion about witness testimony where I understand from criminal trials that the witnesses are not allowed to see other witnesses' testimony. How important is that element, for example? And that's what I mean by procedure.
I understand in that respect, necessarily the televising or the media interpretation of the Oscar Pistorius trial to a large extent, we must consider that this matter was before a court, it was decided upon, and the court subsequently made a decision regarding how, where, and when this is to be placed within the public domain. As this case is progressing, there are applications at certain intervals by the state concerning certain evidence, certain witnesses, and the judge who is currently presiding on that in that matter is necessarily then making the appropriate decision that goes with that.
Correct.
I to a certain extent would think that because this gets transmitted into same day, same minute public domain environment, that it's an added challenge for both parties. Correct, in this instance, and it's simply just something that has to be worked with. But at the end of the day, the court will still take all the evidence that there is, and from that evidence render a judgment that is based on the law.
Complexity and common sense are two words that have always crept up if I ever did a criminal matter. When I say complexity, we refer to complexity of potential terms or legal elements, things such as causal nexus, things such as the facta probanda, things of those nature. Common sense is something, and you mentioned it earlier when you were speaking, is of vital importance to a judge or any presiding officer. Now, let me ask this question in the following manner. Is it fair to say, or is it safe to say, that common sense will always prevail over a situation, say for example in the Oscar Pistorius matter? Now, I'm not asking you for your verdict or even your thought on a verdict, but surely common sense is of vital importance in a criminal trial.
Nadeem, it's very difficult to describe because it creates the impression that a judge is basically going to decide a matter based on a gut feeling.
Okay.
To a certain extent, a presiding officer does develop a gut feeling, and an experienced presiding officer would have an inkling as to a common sensibility looking at matters. But in our criminal law, the onus of proof is beyond a reasonable doubt. And beyond a reasonable doubt, there is an old English case that has a definition for beyond reasonable doubt, and that definition basically goes that reasonable doubt is what causes prudent man to consider for a moment before making decisions in matters of importance.
Correct.
So at the end of the day, you take all the evidence that is in front of you, you wade through it, you take what is fact, you take what is supposition, you look and you start putting the pieces together, you look at what pieces are missing and whether it's relevant for them to be there or not, whether those pieces that are there are taking your case forward or taking it backwards. And through all of that, you go and you apply the law. At the end of the day, our law is quite clear on how you look at witness statements,
Correct.
how you look at testimony, how you regard certain witnesses above and beyond others, how you look at forensic evidence.
Important,
because understandably as well, forensic evidence is simply one aspect of a trial. And no trial court looks at evidence in a vacuum.
Or singly.
It's all looked at in a complete set of, in a complete environment, looking at the probabilities that goes with it.
Let's take this call quickly, Advocate. Assalamu alaikum. Good evening, caller.
Wa alaikum salam.
Yes, you can go ahead. We can hear you.
Yeah, Nadeem, it's Faisal here. I got a question for the advocate, and he can probably clarify a question that I have.
Okay, go for it, Faisal.
I'm also a journalist, and I'm following the Oscar trial, and I know it's imprudent that he can't comment on it, but there's a question or a statement that was made by another advocate from Cape Town.
Okay,
and
go for it.
basically what he said, he says that the South African law may work in Oscar Pistorius' favor for his trial for his girlfriend that he murdered. And he goes on to say, and this is the part I need clarification on. He says, if you mistakenly believe that somebody is about to attack you, or you believe there is an intruder in your house that poses a threat to you or the life of others in your home, you are allowed to take the necessary action. That could be to shoot an intruder. Now he goes on to say that this is unlike in Cape Town, not in Cape Town, in Britain and America, where there isn't such leeway. But in South Africa, there is a leeway that allows you to do this. If you can clarify that issue.
I mean, I know the answer to the question, but I'd love to hear from you.
If you mistakenly think that your life is in danger, it's called what is referred to in our law as a putative defense. And what it basically means is that you are under the impression that something or someone is able to attack you or in some way, and after the fact it turns out that it's not true. Now, our law to a certain extent does not excuse the concept of a putative defense unless your mistaken thought or your mistaken experience is to such an extent that it excludes your guilt, because understanding that all crimes have got the element of guilt in them, they've got the element of unlawfulness in them. Correct. Those are separate concepts. So you don't only prove the crime per se, you have to prove the elements of that crime. And if you mistakenly shoot somebody, then we look at, or at least the courts would look at, to what extent your mistake of that fact controlled your thought process, and in that respect, the court will then guide itself concerning how it's to adjudicate that matter.
And remembering also on that, advocate, that private defense or self-defense, one of the fundamental elements of that is that that threat or danger must have been imminent and threatening, which means that it was about to happen, and you could see it about to happen, right?
Yes.
So it's a difficult one, and I can tell you that from level 2 or second year law, criminal law, that was one of the most fundamental things that we learned about private defense. So, Jazakallah for your question, Faizi. Let's take the next caller on the line. Advocate, good evening. Assalamu alaikum, caller.
Wa alaikum salam. My name is Muhammad Sadiq.
Ji Muhammad.
I don't know if you're only taking criminal, but I got a civil question.
Go for it. We'll see if we can assist you.
Okay. I've got a woman that's renting my place, and she hasn't paid rent for 3 months. And we approached her, and she said, well, it's the new South Africa now, so they don't pay rent anymore. So I think the PI Act, I think it doesn't cover the landlord. It only covers the tenant.
Yeah,
so I think there must be some thing that we can do on the PI Act.
Mohammed, let me answer this very quickly for you, because we've had this question on the show before, and we have also had this topic covered on the show before. It's a very difficult, or it's very long, should I say, explanation, and it's not something that if I give you an answer in a minute that you'll go away feeling like you've satisfied that question. So let me just say this, and it's important that you consult with an attorney. If you cannot afford an attorney, or you have a place, or your income is below or is at the relevant required minimum amount, you can seek assistance from a law clinic or legal aid board. Now, it's very important because PI, as you mentioned correctly, does cover the tenant, and it covers the tenant even if that tenant is a squatter or has taken occupation of that residence. So it's a difficult situation, and sometimes can be a very costly exercise for landlords, but please contact either the RAW or the Wits Law Clinic, and they will be able to advise you very well. They're actually very well trained in these fields specifically, because of the fact that it caters for the sort of lower income earners, and I'm not to say that you're lower income, but certain tenants also will sometimes go and utilize law clinic. I hope, inshallah, you come right with that.
If I could just add to that, the PI Act is not really the monster that it is made out to be. The PI Act actually works quite well. It is just that it is a procedure that needs to be followed, in the sense that a person living in a house, or a squatter, but we're not talking about squatters here, we're talking about a person on whom there is an agreement, and that agreement has not been fulfilled. To apply the PI Act to that situation is actually not a very difficult exercise. It can be done in the Magistrate's Court. It doesn't have to go to the High Court. But as Nadeem said, the best place to start would be with an attorney, and I'm sure that there are willing legal representatives out there that can assist you in this matter at a fair value.
Well, Legal Ease, we're covering not just criminal matter tonight. We've also had a very insightful a bit of advice from Advocate Deon Pool on the PI Act and obviously on evictions. We'll come back shortly and we'll continue discussion on the criminal justice system after this very short ad break. This is Legal Ease. Jazakumullah for joining us. Assalamu alaikum, welcome back to Legal Ease. Just before the break, Advocate Deon Pool was giving some advice on the PI Act, but we're now back to the topic at hand. Yes, he did it, but is it enough? The importance of forensic evidence and, as we can very well see, criminal procedure as a whole in criminal trial. So, Advocate, just before the break, we had a question on this private defense, putative defense from one of our callers. We dealt with that and we sort of covered that, these elements of a crime that need to be proven. And I was asking you about this common sense issue. Now, I have a difficulty with the following thing, especially the version of events that has been put to the court, especially in this Oscar Pistorius. It's been mentioned by our callers, so let's just quickly talk about it. It's sort of this white elephant, I think is what the phrase, in the room.
Elephant in the room.
The elephant in the room. So let's just talk about that very quickly. He hears a noise, he wakes up, he grabs his gun, may or may not have put on his prosthesis, go to the door, either shouts or doesn't shout at the door to this person who he believes to be an intruder, fires 4 shots. Now the question here, the caller asks a very interesting question. He says, you have a private defense, or the person he spoke to has said to him that he has a private defense. But then there's also something else, excessive force. So even if there wasn't an intruder, surely then he's guilty of excessive force. You don't fire 4 shots at somebody who you believe to be an intruder. You fire 1, you say, get out or I'm going to fire more. Am I right? Am I thinking on the right track? Or
It all depends. It's very dependent on the circumstances. And once again, not speaking specifically about the Oscar Pistorius matter,
yes,
understanding that you're in a self-defense defense, there are various elements that you have to prove as far as your self-defense. You alluded to one, necessarily that the attack must be imminent. One of the other aspects that needs to be proved is whether the force that you applied in order to defend yourself exceeded the bounds of what is considered to be reasonable force.
Correct.
Now, that all depends on the circumstances in which you find yourself. If you are lying in bed and there's an intruder in your house, and the only means that you have at your disposal in order to protect yourself is to necessarily kill that person, the court will look at those circumstances, apply the law once again to it, because there is various case law on this issue that goes from top to bottom and discusses most probably every single scenario that could possibly exist in our current world, discusses it inside out, and apply the law to that situation. And eventually, in my experience, every single time, if the justification was there and it was proper and it was well-founded, it succeeded.
Let's see if this caller can add to that. Good evening. Assalamu alaikum, caller.
Wa alaikum salam.
Ji, you can go ahead.
I'd like to say anonymous.
Ji.
I've got a question. It's got to do with property. Is it okay?
Sorry, it got to do with?
Property.
Property.
It's fine. We just might not be able to elaborate too much.
I'll try to be quick.
Yes.
We purchased a house from a seller where we live on an Islamic basis. We agreed there's going to be no interest. He drew up the contract with the agreement that we're going to be paying a certain amount per month and the term to be paid off for 12 years. But like about a few months after we purchased, we had addresses from the bank coming to the house. And then we got it at the thing, we inquired why and all that. So they said they didn't say it. I somehow found out that they're going to take a loan, a bond, and do the houses collapse. Okay, to cut a long story short, 2 years after that, we had to get a lawyer, an attorney, and luckily for us, according to our attorney, it was that our agreement is valid but not good enough as far as property laws are concerned. So we did an endorsement with the deed office. I don't know all these legal terms too well.
Sounds right, yes.
And, he put an endorsement on the property. After that, 3 years ago. We got letters of demand. We've been making changes and changing carpets and taking off wooden panels and things. So we had to do it just out of cleanliness and improvement and all that, right? This matter went High Court through them. So they sent us a letter from the attorney. Now what has happened, we can't get, the house is paid off, full, and we can't get our house in our name, the title deed, because the title deeds are with the bank, and they've got 1 or 2 bonds, and
Sister,
the bank don't want to get involved.
Sister, if I can just stop you there, I hear your question, and it actually sounds like it has a lot of very complex facets to the question, some of which deal with the Alienation of Land Act, some of which deal with property transfers in the country, some of which deal with contractual law, payments of monies, interest, and all those types of things. And we definitely can assist you. Unfortunately, we are running out of time, and we need to cover certain elements of the topic at hand. Would I make a request that you send an email or a tweet to myself, or even to Advocate Pool? I'm sure Advocate Pool would be able to assist you. His email and my email both appear at the bottom of the screen. I'm so sorry to cut you off. Unfortunately, it's not necessarily the topic of the show, and it'll be difficult to engage on this at length. So, sister, if you don't mind, if you could just send me your email or your tweet. The tweet is at LegalEase, which is on Twitter, or my email address, or the Advocate's email address, which appears at the bottom of the screen.
Necessarily, there appears to be some Sharia law that was applied to this transaction as well that needs to be considered.
Okay, Jazakallah khair.
Okay, one of the questions that have come on Twitter was a issue of juries. People say, maybe there should be juries in South Africa as there are in America. Your comments on that?
No. My comment on that is an emphatic no.
Good, I'm glad.
The jury system is as far as my personal opinion goes, a pandering to the emotions of 12 people. Whereas in South Africa, our law, bringing back to my point, we've got checks and balances in our law. Yes, presiding officers are trained in and skilled in the environment in which they are working in, and they have to apply the law. And if they don't apply the law, you have the right to go and appeal that decision and to take it to the highest court in the land. From the Magistrates Court to the High Courts, the High Court to the Supreme Court of Appeal in Bloemfontein. If you have a constitutional issue, you can refer it to the Constitutional Court. I would definitely not be a proponent of a jury system under any circumstances in this country, because I feel that our justice system is more than competent enough to deal with the matters at hand.
And having said that, and it's a little bit off the topic specifically, we've got a few minutes to wrap up the show, but I just want to ask you, are you then comfortable with the appointment of the judiciary in accordance with the Constitution? There's been much talk in the legal brief and law society and so forth amongst the legal minds that there is some a bit of some people are not happy, should I say. Some legal minds are not happy with how judges are being appointed and on what basis. Just very briefly.
Very briefly, Nadeem, the thing is that necessarily there is a system in place. The Judicial Services Commission is the body that invites and appoints judges, and they have got a certain mandate to deal with it. We must also understand that our current dispensation demands that there is transformation in our judiciary, and it is policy, and any good legal practitioner will align himself to the policy, because eventually policy becomes law, and as legal practitioners we have to apply the law. If the manner in which judges or presiding officers are appointed is lacking, then I'm sure that it will be addressed from the necessary sources, and it will eventually be placed. And there are very senior people in our environment, be it advocates, be it attorneys, be it judges or presiding officers, that can deal with those matters. But I still think that the way in which we do appoint our presiding officers is primarily the best way in doing so. I do not want us to move into an environment where we start electing people to the bench, because one of the criteria is that you necessarily have to be a fit and proper person to have an appointment of such high regard in our legal system.
Correct. Well, I mean, as you can very well hear from all these answers this evening and all the advice given, Advocate Pool is confident and has a lot of faith in our justice system, and I suppose he's been on both sides of the fence, as I said in the beginning of our show, so he should be. On the other side of the fence, Advocate, is the view different?
The view is more comfortable, if I can put it that way.
The cushioning is more comfortable, but the view do you have the same perspective of the justice system, sitting on the side of the defence? You started out as a Harry Nell, you're now looking to be a Beirut, so to speak.
I think it's a natural progression. There are some people that consider being in law a calling, in the sense that they remain prosecutors. I spoke to a senior member of the NPA the other day who said to me, "Don't tell me to come to the bar. It is a calling for me. I'm remaining where I am." For me, it was a natural progression to move from the bench to being an advocate, specifically because sitting on the bench, I have to apply the law, whereas an advocate, and I will hopefully one day be one of the giants on whose shoulders I am standing, those people make the law and they make a contribution to the law.
Correct.
And my intention is to become part of that fraternity that facilitates and makes that contribution in order to move our country forward.
In summary, in conclusion, we are almost about to wrap up. What are your thoughts on, well, and I don't want to necessarily say on the Pistorius trial specifically, but on trials of this nature, do you think that the outcome, should I say, will be a satisfactory outcome to the viewers, or do you think that we will have some questions that are still going to be asked? The issue has always come up about whether or not Oscar will take the stand. How important is that, in your opinion?
The fact of whether Mr. Pistorius will take the stand or not is necessarily a decision that will be made by his defence team when the time arrives for that to happen. And it is a decision that will remain with them in that sense when as they look at what the state has presented against them. Fundamentally, it would be imprudent for myself or anybody for that matter to make a comment concerning that trial at this point in time. Apart from the fact that it's not done. There is a trust relationship that exists between a client and his advocate.
Absolutely.
And for people to go and make comments, for people such as myself to go and sit and make comments about this and necessarily prejudge the matter would affect that trust relationship to a very large extent. But coming back to the question that you actually asked, I think that we need to look at the way in which this trial is running. Yes, it's a completely new environment. The fact that the media has got daily access to it, and it adds a challenge to the environment, and that I can agree with. But there was a Harvard professor who made a comment the other day that South Africa was a failed state. And I think just by looking at the way that the Oscar Pistorius trial is being run at this point in time, anybody who is watching this trial being done, despite the fact that we have a fly-on-the-wall view of that courtroom every day, cannot be of the opinion that South African justice system is not working, and it's not working the way that it should.
Well, there you have it from a man who's been on both sides of the fence, and some people say that the best criminals are the best lawyers, or best advocates, best judges, best magistrates. Fortunately for us, we have someone like Advocate Pool on the side of the defense, and somebody who is competent and will one day be part of the Bar Association of Johannesburg. We say goodbye, assalamu alaikum, and thank you very much to the viewers as well as to our esteemed guest. Thank you very much, Advocate Pool.
Nadeem.
We hope that you enjoyed this show, and we hope that if you have any burning questions that we have not been answered, that you tweet us at Legal Ease. We'll see you all next week, Thursday, on Legal Ease, the show that converts legal jargon into legal ease. Assalamu alaikum wa rahmatullahi wa barakatuh.